Lord,
Yes,
my lady,
Mr. Marsh.
I was about to go on to my proposition 5. Before I go there, I'll perhaps just touch on the proposition made by my learned friend that trade includes a business. We say that makes no difference to my argument at all. Because assume for the moment that the LLP was carrying on a business as opposed to a trade. In fact, it carried on a trade, but suppose the moment it was carrying on a business. Then the profits are determined as if the notional company carried on the business during the relevant accounting period. And that says nothing about how the IFAs were acquired or obtained or anything like that. It simply requires it to be assumed that it had the IFAs and used them in the course of its activities.
Sorry, your voice dropped at the end of that last
I'm
bit.
sorry, my lord, that it simply requires it to be assumed that the notional company had the IFAs
Yes.
and used them in the course of its activities, or in this case, its business.
Yes.
Well, that takes me on to my last proposition, proposition 5, which is that if the proper assumptions are made, each of the corporate members is a related party in relation to the notional company and the appeal fails. Now, I had reasonably lengthy submissions to make on this, but my learned friend has accepted that if the notional company had the ownership characteristics of
Yes.
the LLP, then it was controlled and was a related company. And the only matter I'd raise is just you shouldn't be at all surprised by that, because in the Corporation Taxes Act, company includes any body corporate and unincorporated associations. So it's dealing with a whole raft of things, not only companies with shares, companies without shares, companies limited by guarantees and unincorporated associations. So the notion of controlled is going to be perfectly general.
Just remind me, or tell me if I've forgotten where that wide definition of company.
Oh, it's a bit of a trek. If you start in Schedule 24 of the Corporation Tax Act,
We've got the section in the
you do, my lord. I can take you through it slowly if you like. I've got here we are. My lord, if you turn to tab 8 of the bundle, page 181. Has you got that?
Yes, sorry, Schedule
4. This is Schedule 4 of the Corporation Tax Act 2009. That's an index of defined expressions. It's going to be a little bit of a journey. But if your lordship then turns over to page 184, you see there's a list of company, and we're concerned with
7 definitions of company.
my lord, yes. Unfortunately, we're only concerned with one, which is the first one, company, except in chapter except for chapter 8 of part 8. That's groups of companies, so we'll leave that to one side. But basically, it's a general thing. All the rest are applying to different provisions. And the definition is section 119 of the CTA 2010. If one then turns to tab 9, that's section 1019 of the Corporation Tax Act 2010. And if you turn over the page to page 201, so you'll see rather frustratingly, company has the meaning given by section 1121.
This is great fun.
So, but this is the end of the paper trail. If your lordships will turn to tab 10,
I thought the tax rewrite was supposed to make things simpler.
Yes, quite.
Well, my lord, your lordships will have noticed that the yellow book has gone from 1 volume to however many it is now. It certainly made things lengthier.
The idea that any normally intelligent adult should be able to understand it without expert assistance is frankly
It's for the
pie in
birds.
sky.
Yes. If your lordships would turn to tab 10 at page 2006, and this is the end of the journey, definition of company in the Corporation Tax Act, so that includes the 2009 Act.
Sorry, I've lost you. Where
Sorry,
which
tab
page?
10, page 206.
Thank you.
This is where the various signposts have eventually taken us via a circuitous route.
So is this definition applicable to section 1259?
Yes, my lord, because 1259 is in the 2009 Act.
So when we're told to assume that the trade of the pretend partnership is carried on by a company,
A company could mean,
an unincorporated association.
my lord, yes. Which is one of the reasons, my lord, we say you have to come to this with a dose of realism. You can't assume that this is just a company with no ownership characteristics at all. You have to assume that it's a company which can cover all these sorts of beasts. And I ought to, just for completeness, say that your lordships will see that the meaning in the 2009 Act is now defined in the 2010 Act. Prior to the 2010 Act, the meaning in the 2009 Act was defined in section 832 of ICTA, which was in materially the same terms.
Sorry, which section of ICTA?
832.
Thank you.
Theoretically, could one assume for the purposes of section 1259 that the trade is carried on by an LLP, which is a body corporate?
Well, I suppose so, yes. Well, but yeah, I mean, a company doesn't include a partnership.
No, but an LLP isn't a partnership.
But it's deemed to do one. So
But it's deemed to be one. Yes. Yes. We don't put the argument in that way, my lord, no.
connoisseurs of deeming, this case has quite a lot of counterfactuals.
It does, my lord, which is what we say you must just keep one's eye firmly on the reality of what's going on.
Right.
My lord, if you want the precise way in which control is established, it was set out in paragraphs 22 and 23 of the Upper Tribunal's decision. That goes through it. I don't think there's any dispute about that.
Is it 3 and 24?
Sorry, my lord,
Behind you on
22,
numbers again.
22 and 23.
22 and 23, thank you.
I've got the page reference as well.
No need for that, just the,
It's on page 50, my lord.
thank you.
Yeah.
So, my lords and my lady, that brings me on to the assertion that there's some sort of cakeism going on here because we ignore the group provisions. It was put in the appellant skeleton that we were trying to have our cake and eat it. I didn't actually hear my learned friend say as much this morning, but the argument is that we are saying that the real world characteristics of the LLP must be applied to the notional company so that a full computation can be carried out. And the appellants say that a crucial part of the architecture of Part 8 is the group provisions. And they say to apply those group provisions, one has to know whether the company is in a group. And they say, well, the tribunals below didn't consider it was possible to attribute shares to a company. And therefore, they say, we can't have our cake, that is, that the corporate members are related parties in relation to the notional company, and eat it, i.e. that they're not members of a group. Well, my lord, I don't want to push this analogy too far, but we don't recognise the cake. We don't recognise that we're trying to eat it. All we say is that the notional company must be assumed to be controlled in the same way as the LLP. And that enables it to be decided whether Part 8 applies or not. That also enables it to be decided whether the group provisions apply. If, as the tribunals below held, the notional company has no shares, then it can't be part of a group. So it's simply a matter that on our case, the notional company, the corporate members don't get the benefit of Part 8. And actually the group provisions don't apply at all. But if the corporate members did have the benefit of Part 8, the group provisions would not apply because they wouldn't have shares. Don't see a problem with that. I mean, we would say that, as my learned friend recognised, same applies in the opposite direction on their argument. They say that their corporate members are within, that Part 8 applies to their corporate members, but the group provisions don't apply. Precisely the same result. So we say there's no objection in that argument at all.
And the argument that Mr. Peacock was advancing based on the group provisions, I mean, my impression is that didn't feature in the tribunals below, unless I've forgotten something.
I think it was raised. There were a lot of issues
All
raised.
affairs was that running? Yes.
Yes.
Yeah.
Yeah.
Anyway, I mean, then no point is being taken about it
No.
not being open to him to run the
No,
point.
no, but it's a pure point of law, so it'd be useless taking that point.
Yeah, thank you.
Then lastly, my lord, and I don't believe my learned friend actually pressed this point today, but it was said in his skeleton that the advice with the decisions below and with our argument is that we are trespassing into legislation. We're not applying the legislation. We're inviting you, we invited the tribunals to undertake judicial legislation. And my lord, we say, no, that's not right. The first thing is that the appellants relied in their skeleton that the meaning should be clear from the words in the statute, and that's precisely the burden of our submissions to you, is that you apply the meaning of the words in the statute. And so, my lord, we say that there's nothing in that point either. So, my lords and my lady, if I can just sum up then, we have two propositions. First, that Part 8 cannot apply to a firm on the appellant's arguments, or to the LLP on the appellant's arguments. Secondly, HMRC submits that Part 8 can apply to a firm, but that is possible only if Section 1259 is construed taking into account all facts and matters surrounding the transaction, and assumptions are made accordingly. And so if I said there were two parts, I'm sorry, there's a third, which is that on that basis, each of the corporate members is a related party in relation to...
I think you would say on either basis.
Hmm?
On either basis.
Well, on either basis, well, my lord, perhaps yes, but each of them is a related party, and the appeal fails.
Yeah.
My lords, unless I can help you further, those are my submissions on the first point.
Thank you very much, Mr. Marsh. Yes, Mr. Afzal.
My lords, my lady. My lords, my lady. I'll be addressing you on the second issue, Finance Act 2016, which is only relevant, of course, if the appellants are correct on the first issue. If they're wrong on that, then this doesn't add anything further. As my learned friend said earlier this morning, and as appears in their skeleton at paragraph 62, it's common ground that the participation condition in section 148 of Taxation, International and Other Provisions Act 2010 was met as between the corporate members and the LLP. But whether the Finance Act 2016 has any impact in this case turns on two sub-issues. The first is whether it's capable of applying in circumstances where the relevant acquisitions occurred before the commencement date of 25th November 2015. And the second sub-issue is whether a drafting error, the existence of which is common ground, can be corrected by the court and before them by the tribunals. Both the first tier tribunal and the upper tribunal decided both of these sub-issues in favour of HMRC, and we submit that they were correct to do so. Starting with the first sub-issue, the commencement, and whether the provisions can have effect in relation to acquisitions prior to 25th November 2015, the starting point is to briefly look at the commencement provision, which you can find in the hard copy bundle at page 210, 227 electronically. Section 52 of the Finance Act 2016, and we can see over leaf in subsection 5, the amendments made by this section have effect in relation to accounting periods beginning on or after 25th November 2015. In a nutshell, the issue is this. It's common ground that corporation tax is an annual tax, and that in relation to any given accounting period in which debits are sought, one must apply the legislation and see if its terms are met. One of those requirements in the legislation, in section 882(1)(b), turns on whether the parties were related at the time of acquisition. My learned friend Mr. Peacock showed you those words. Now, there's no dispute that in answering that question, one looks at the facts that actually prevailed at the time of acquisition. The question is, when analysing those facts from the time of acquisition, does one apply the historic law which prevailed at the time of acquisition, which is what my learned friends propose, or do you apply the current law presently applicable at the time when the debits are sought, as we submit? And the FTT and UT agreed. There are, we say, 5 reasons why we and the tribunals below were correct. The first, and this was the key reason relied on by the FTT and also the key reason relied on by the upper tribunal, is the fact that that corporation tax is an annual tax. Now, the upper tribunal discussed this and the consequences of it being an annual tax at paragraph 76 of its decision, which my learned friend took you to. And its reasoning in paragraph 76 can be summarized thus. What the upper tribunal correctly said is that the question of whether parties are related at the time of acquisition is only relevant if debits are sought and then disputed. So what they meant was it doesn't have an independent or an abstract relevance. One isn't in the abstract considering, or for independent reasons considering, were the parties related at the time of acquisition. One is only doing so in the context of debits having been sought in a particular accounting period. And so it doesn't make sense for the new law under the 2016 Act to only apply to acquisitions after the commencement date in circumstances where corporation tax isn't primarily interested in acquisitions. What it's primarily interested in is debits and whether they're deductible. And so, said the Upper Tribunal, it makes most sense that the new law, the amendments, should apply to debits that are sought after the commencement date, irrespective of when the acquisition was. Put another way, since acquisitions are only relevant when debits are sought in a particular accounting period, it doesn't make sense in that accounting period to go back and look at a historic legal position. What CET is fundamentally concerned with, corporation tax is fundamentally concerned with, is the time when you're seeking the debit. And so it makes most sense to apply the law as it stands at that point in time. Now,
I mean, would you accept that the tribunal, the Upper Tribunal, went a little bit too far when it said it, i.e. corporation tax, was not interested in the date of acquisition?
so I was about to come to that, my lord, and the answer I was going to give was this. Read in context of paragraph 76 as a whole, what we submit is what the Upper Tribunal meant was not that the time of acquisition is irrelevant, and it clearly can't have thought that. It says it in the legislation, that there's no way that the Upper Tribunal will have thought that the question of acquisitions is simply irrelevant. But what it meant was that it plays a secondary role. The primary role, the primary interest of corporation tax is in the debits being sought in a particular period.
So you say this is just a piece of clumsy phraseology?
Absolutely, my lord.
Right.
So in short, that first point, which the Upper Tribunal and the first day before it made, is this. Corporation tax is an annual tax. The question is whether debits sought in a particular period are deductible, and therefore it makes most sense to apply the law as it stands in that period.
Yeah, well, you got that point.
So that's the first reason. The second reason why we say this is the correct answer flows from the fact that when legislation is amended, typically the intention is to produce a revised text which can be read as a whole. So you look at the amended legislation as a freestanding piece of legislation. And one can see that in the bundle at page 425. This was my Lord Justice Henderson in the GDF Suez case.
Sorry, give me the reference again.
It's in the hard copy, it's page 425. What page did I didn't catch that, my lady?
Divider 19. I was just trying to be helpful.
Thank you.
And there are 45.
425 in the hard copy, and it's paragraph 87, which is marked at the side.
Yes.
But perhaps in the interest of economy, I might ask you just to read that paragraph to yourselves, my lord and my lady.
Yes.
So one can see there that usually when legislation is amended, you apply it as a freestanding whole, and we say that reinforces or adds weight to the argument that one applies the law currently applicable at the time when debits are being sought. So, in other words, so when you're seeking debits on or after the commencement date of 25th of November 2015, Section 882 must be read as a freestanding whole, taking into account the amendments, and you look at it as a whole with all its subsections, including the expanded definition of related party, and reading that as a whole, you answer the question which is asked by 1B, were the parties related at the time of acquisition? So that's the second reason we say we and the tribunals were correct. The third reason is based on the explanatory notes, and my learned friend took you to the notes, but he missed out or didn't go to one particular paragraph, which is at page 684 of the hard copy bundle. It's paragraph 10. Just before I mention that, one point I intended to mention on the GDF Suez point was just for your note that the FTT had considered that the revenues interpretation was consistent with the principle from GDF Suez about reading legislation as a revised whole, and that was at paragraph 143 of its decision, 143. And although the Upper Tribunal didn't expressly refer to the point about GDF Suez, it did say at paragraph 76 that the FTT was correct for broadly the right reasons. Coming back to the explanatory notes, paragraph 10 says, subsections 5 to 7 set out the time from when the changes apply. The new rules will apply to debits or credits arising in accounting periods beginning on or after 25th November 2015. For that purpose, an accounting period is split into two notional accounting periods, one ending on the 24th November and one beginning on 25th November. The rule applies to debits and credits irrespective of when the relevant transfers of intangible fixed assets took place. Now, I should say for completeness that the FTT considered that this was not persuasive in and of itself, and that was at paragraph 137 of its decision. And that was on the basis that the wishes of government are not the same as Parliament.
Well, can I just ask you this before we go on? The explanatory notes that we are looking at are the notes to clause 48 of the Finance Number 2 bill,
which became Section 52.
So something clearly changed between the time that these notes were prepared and the time that the bill became law, not least because what was clause 48 is now Section 52. Do you know whether there was any change to sub-clauses 5 to 7 of the bill as opposed to Section 52(5) as enacted?
Those behind me will check to see whether there were any changes. I'm not aware of any, but we will double check.
My recollection from Binion et al. Is that slightly more weight can be given to explanatory notes that were before Parliament when the legislation was passed, as opposed to those which are prepared after the enactment of a particular act.
Well, in terms of taking the 2 points in turn, in terms of whether there are any changes to subsection 5 or 7, we'll those behind me will check that. Although the fact that the number has changed from 48 to 52, I would say doesn't imply in any way that subsection 5 is changing.
It's not of significance in itself.
No, precisely.
But it just shows that the bill
Some
as
things
presented to Parliament wasn't necessarily the Act that Parliament passed.
Quite, my lord. I take that, and I'd say the obvious implication is that new sections were added earlier in. In terms of the weight that can be given to it, taking into account Benyon, or actually R&O deals with this in terms. I was going to take that to you right now, and then explain why we say that this is helpful. But just before doing that, I thought for completeness, I'll tell you that the first tribunal thought explanatory notes weren't persuasive in and of themselves, and the upper tribunal didn't comment on this particular piece of the explanatory notes. It did comment on our reliance on the explanatory notes for the second sub-issue, the drafting error, but not in relation to the first sub-issue. But I think since it said the FTT was right for broadly the right reasons, you can assume, I think, fairly that the upper tribunal didn't place weight on this either. But we say that they could have done. They don't need to. They don't need to rely on these explanatory notes to get home, as it were. That there's enough, we say, in particular from the annual nature of corporation tax and the points I've made. But this adds further weight to it, or it gives further comfort. And we can see that in R&O, which is it was Lord Hodge at page 564 of the hard copy authorities bundle.
Yeah, paragraph 30.
Quite right, 29 to 30, my lord. What we see from paragraph 29, which I don't need to read out, is that Lord Hodge was saying that primarily, let me turn up the page, it was page 564 in the hard copy, my lord, my lady.
Yeah.
So what's being said at paragraph 29 is that primarily one relies on statutory context when interpreting words in legislation. So by statutory context, they mean other words in the same provision or other provisions in the legislation. But at 30, the Supreme Court said, external aids to interpretation therefore must play a secondary role. Explanatory notes prepared under the authority of Parliament may cast light on the meaning of particular statutory provisions. Other sources, such as Law Commission reports of Royal Commissions and Advisory Committees and government white papers, may disclose the background to a statute and assist the court to identify not only the mischief which it addresses, but also the purpose of the legislation, thereby assisting a purposive interpretation of a particular statutory provision. And so we say explanatory notes based on this can cast light on the meaning of provisions, but presumably they can also do what Law Commission reports and so on can do, because those are a lesser role in terms of disclosing the background and the mischief. So Lord Hodge wasn't saying here, although it's perhaps not entirely clear, but he wasn't saying explanatory notes are only for the purpose of casting light on the meaning of a provision. Presumably the rest of what he says about disclosing the mischief and purpose is also included, because in a sense that's lesser than casting light on the meaning of the provision. And in fact, one can see that at page 574. And this was Lady Arden in paragraph 64. It was just one sentence before she quotes from the Spathome case. Her ladyship said, there are occasions when pre-legislative material may, depending on the circumstances, go further than simply provide the background or context for the statutory provision. It may influence its meaning. So that just helps when one's reading Lord Hodge's comments. You can say influencing the meaning is a greater role than disclosing purpose and so on. So if the explanatory notes can influence the meaning, then a fortiori they can assist in working out the purpose or the mischief. And so what we say here is, and we're checking, my lord, your point as to whether there were any changes.
Well, Lady Arden seems to be in a lone voice.
So Lady Arden's point was where she was going further, in a nutshell, and you can see this most clearly at page 549 of the hard copy. This is the head note, but it's just to show where my ladyship was different. In the last sentence next to H, but per Lord Hodge, Lord Briggs, Lord Stevens, and Lady Rose, none of these external aids displace
Yeah.
the meaning conveyed by the words of the statute, that, after consideration of the context, are clear and unambiguous. It was in that respect, you see, Lady Arden's not mentioned there. She was going further. So I'm not relying on Lady Arden for the approach that she sets out. It was just it helps slightly when one's reading what Lord Hodge is saying. He says explanatory notes can cast light on the meaning of provision. His Lordship then says things such as Law Commission reports can disclose the purpose. And I say, well, a fortiori, explanatory notes can do so as well, because influencing the meaning
All right, we've
seems
got
to be a
that.
higher category of thing than simply disclosing the mischief. And we say subject to there having been no relevant change, which is being checked by those behind me. Reading that paragraph 10 of the explanatory notes, we say, I didn't put as much higher than this, but it casts some light on the meaning, or it shows you what the commencement provision was designed to achieve, or at the very least it gives one added comfort.
Yeah.
So I wouldn't be saying, look, it's just the explanatory notes, it's inconsistent with everything else, but the explanatory notes get us home. That's not what I'm saying, but it's just an added factor which gives added comfort.
Understand. Right, what's the fourth reason?
The fourth reason, my lord, is to do with the splitting of the accounting period. So you'll remember that if an accounting period straddles 25th of November, it's split. And we say that's consistent with our interpretation, whereby the aim was from 25th of November onwards, any debits that are sought are affected by the new law, irrespective of when the acquisition happened. I'll come back to my learned friend's interpretation or explanation for the splitting in one moment. But for your note, at paragraphs 139 and 140 of the FTT's decision, they discussed this, and the FTT considered that the only reason for splitting a straddling accounting period was so that the extended definition of related party would apply to any debit sought after 25th of November in respect of past acquisitions. They thought that was the only reason. And so they said that this was therefore supportive of the revenue's interpretation being correct. The Upper Tribunal is said by my learned friend in his skeleton, it said that the Upper Tribunal didn't rely on this point about the splitting of the accounting period. We say that's not quite right for two reasons. One is, as I've already said, the Upper Tribunal said the FTT was right for broadly the right reasons, but also, and I'll be coming back to this in another context, but at paragraph 77, the Upper Tribunal said it wasn't assisted by other commencement provisions, but it didn't say it wasn't assisted by these detailed commencement provisions. So we say, well, it appears that the UT may well have relied on this or may well have thought it was correct. And ultimately, of course, now it's for my lords and lady to decide the relevance of the splitting of the accounting date. We say it's perfectly consistent with our argument. Now, what my learned friend says is, well, even if the legislation was only intended to apply to future acquisitions, as he says you can still make sense of the splitting of the accounting period. And he says, well, the reason is that any acquisitions from 25th of November onwards would now be subject to this new regime, rather than waiting until an existing accounting period had ended, which might be some months in the future. Now, I don't say that that's an entirely implausible or impossible explanation. That might be why the straddling accounting period is split, but we say for two reasons that's unlikely to be the better reason. Instead, the better reason we say is the one which we rely upon, meaning that all future debits are covered by these changes, by the expanded definition of related party, irrespective of when the acquisition happened. And we say that for two reasons, why our explanation is better. The first is that it's noteworthy that the FTT, considered at paragraph 139, that our interpretation was the only explanation for the splitting of the straddling accounting period. And they also said at paragraph 139 that Mr. Trevitt, who was appearing for the appellants at that time, did not provide us with any other explanation. Now, I don't say that's decisive, but the fact that neither the FTT nor the appellants at that stage were able to think up an alternative explanation for the splitting of the straddling accounting period, we say tells one something. But even more so, we say, and this will then seg into my fifth reason, is that if the legislation had been intended to only apply to future acquisitions, that very clearly would have been stated. It would have been very easy for Parliament to do. But not only would it have been very easy for Parliament to do, it actually did it in the very next provision. And if one looks at section 53, which is page 212 of the hard copy bundle, my Lord, I've been told that clauses 5 to 7 in clause 48 of the Finance Number 2 Bill, 2016, were identical to sub 5 to sub 7 in section 52.
Thank you.
Thank you.
So you're now looking at section 53, subsection 2.
Well, precisely. So starting with subsection 1, which my learned friend did take you to, you can see that it's in a very similar structure to section 52. So it introduces 4A and so on, whereas section 52 introduces 5A. It's dealing with a similar type of topic. It's transfers between companies and related parties. But interestingly, what subsection 2 says, the amendment made by this section applies in relation to a transfer which takes place on or after 25th of November 2015, same date, unless it takes place pursuant to an obligation under a contract that was unconditional. Now, what we say is when you've got, although the UT said it didn't find other commencement provisions to be of assistance.
You say there's a contrast between these
we
two.
say
and
absolute
it's absolutely
contrast when you've got two sections dealing with a similar topic,
Yeah.
similar structure. If Parliament had intended, transfer and acquisition, one can say, are interchangeable terms. So if Parliament had intended section 52 to only apply to transfers or acquisitions after 25th November 2015, surely it would have used the form of
right.
wording it's used here.
Right. Fifth reason?
That was the fifth reason.
That was the fifth.
That was the fifth.
Right.
I segged from the fourth into the fifth.
Right.
Now, dealing here with 2 points that my learned friend made, before I move on to the second sub-issue, one point he's made in his skeleton, he didn't say it orally, but he said, well, the changes made by section 52 are not retrospective. And we say, absolutely, we agree with that. It's not the case that if in a prior year debits had been allowable, that you now go back and say, well, they cease to be allowable. The mere fact that for the future, the answer might be different under the revised law than what it was in a previous year doesn't make this in any way retrospective.
Yeah.
And the second point, which my learned friend, again, I didn't think he made it orally, but it was in his skeleton, was to say that specifically in the context of this first sub-issue about commencement, my learned friend said, well, the issue was addressed by the Upper Tribunal on the assumption that it was wrong on the first issue, that it had found for the appellant on the first issue. And we say, well, actually, that's wrong. When the Upper Tribunal started its commencement, commenced its discussion of this, which is at paragraph 69 of its decision, it says that the Finance Act 2016 issue is only relevant if the appellants are right on the first issue. But it didn't say, the FTT did, but the UT didn't. It didn't say that it was assuming that the appellants were right on the first issue. And the reason that's important is this. In a general colloquial sense or practical sense, one can say, well, we're considering this on the assumption that they've won the first issue, because otherwise it doesn't add anything. But it's strictly not a necessary assumption in the sense that this is an additional reason why the gateway isn't satisfied. Or put another way, it's not necessary for the revenue to be wrong on the first issue dealt with by Mr. Tidmarsh, my learned friend, in order for us to succeed on the second issue to do with Finance Act 2016. So it's a small point, but it's not the case that we have to have lost that in order to win on this. We can, and we say we should, be able to win on both arguments, and they're both separate reasons why the gateway in 1B is not met.
I'm just trying to see what the practical impact of that is. I think, correct me if this is wrong, that what you are really saying is that we should decide both points. We shouldn't, for instance, say, well, you're right on the first point, so the second point doesn't arise.
Well, absolutely. In practical terms, I'd say that's probably the impact, my lord. To be frank, when I read the point in my learned friend skeleton, I couldn't see any practical relevance of the point, but since it's there, I thought I should address it.
Yeah.
Very strictly, it's not an assumption. It's not relevant if they win on the first. It's only relevant if they win on the first point, but it's not a necessary logical assumption that they've won.
Right, understood?
Turning then to the drafting error point, the second sub-issue, it's common ground, and you can see this even in the Upper Tribunal's decision at 79, that there's a drafting error, the drafting error being the misdescription in subsection 5B of how 1259 operates. And we know from INCO that the court must be abundantly sure of three things in order to correct the drafting error. The intended purpose of the provision, that the error was by inadvertence, if by inadvertence Parliament and the drafter failed to give effect to the purpose, and then the substance of the provision, but not necessarily the precise wording that Parliament would have used had it been aware of the error. And both the FTT and the UT were satisfied with the 3 points, and in turn found in our favour, and I'll briefly go through all three. So in terms of the intended purpose of the provision, our fundamental point is that it's clear from the terms of the provision themselves. I'll come back in a moment to the explanatory notes and how they might help, but fundamentally from the provisions themselves, the purpose is clear. And it may be helpful to briefly turn up 882. One can see this on the revised version at page 3 of the bundle. And the newly inserted 5A onwards are at page 4 of the bundle. So we say just looking at 5A to C, D ties in, it's a definition of participation condition. It tells you where to find the definition. It's clear we say from 5A that what it's doing, and I think my learned friend accepted this, is that it's expanding the definition of related party so that you have related parties in circumstances where the participation condition is met. So that's clear from 5A. 5B, which is the one that contains the error, we say what is clear from there is that in certain circumstances, and I'll come back to what those circumstances are, but in certain circumstances, it's clear that what Parliament intended is that the word person in 5A includes a firm or partnership, and therefore, under 5A, the participation condition is applied, and thus related party status is tested by reference to a partnership. So that's clear from the wording of 5B. And then third, what's clear, we say from the reference to the words section 1259 purposes in 5B, so it expressly says section 1259 purposes, 5C tells us what 1259 purposes are. We say it's clear from those things that the circumstances in which Parliament intended what I've just explained the 5B was meant to achieve, the circumstances it wanted to do that, the circumstances it wanted you to test the participation condition by reference to a partnership, is when one is applying section 1259, i.e. when you're working out the profits and losses, or losses, of partners. So the purpose is quite clear, and the UT went through a similar analysis at paragraphs 80 5 to 87 of its decision. And one can almost look at it another way, which picks up on a point my Lord Justice Lewison made earlier, which is, well, fundamentally the issue here is simply 1259, how it works, has been misdescribed. If that error hadn't happened, there wouldn't be a problem here, there wouldn't be a drafting error. So mentally, if one just assumes for a moment that 1259 were properly described, then one can read the provisions and quite easily work out what the purpose is.
Yeah.
Now, I'll come back after going through the main three criteria from INCO to deal with my learned friend's points about, well, even if you correct the drafting error, that doesn't fix the problem, and I'll come back to that. Pausing here still on the purpose. So fundamentally, we say it's apparent from the provisions as the UT considered. The UT said it was possible to discern the purpose, this was at paragraph 85, from the provisions themselves without recourse to the explanatory notes. The first tier, on the other hand, at 148, had said the purpose was apparent from both the terms of the provision and the terms of the explanatory notes. Now, we say, in one sense, the Upper Tribunal was right. You don't need to go to the explanatory notes to work out the purpose. It's very clear from the provisions themselves. But nonetheless, they do give some further comfort, and we've already looked at R and O, so we don't need to go there again. But if I could ask you to briefly turn up page 685 of the authorities bundle. Which is the explanatory notes, and page 685, and it's paragraphs 13 and 14, if I could ask you just to read those to yourselves.
Yes.
So what one can see from those paragraphs, my lords, my lady, is that Parliament was seeking to alter the conditions in which Part 8 would apply. And it was seeking to do so such that Part 8 would not apply in circumstances where assets are transferred to an LLP or a partnership without a effective change in economic ownership. So that reinforces, one can see it from the provisions anyway, but it's a further resource showing us what these provisions are all about. Now, in terms of the second INCO principle, frankly, that's obvious, that by inadvertence, Parliament has failed to give effect to the purpose. That's obvious. Section 1259, rather the way it operates, has been misdescribed in 5B.
Yeah, well, that's common ground.
And exactly, and on its face, therefore, the 5B would have no effect. And then the third INCO principle, it's the substance of the provision Parliament would have made, although not necessarily the precise words Parliament would have used. And if I could ask you to turn to page 339 of the authorities bundle. So, yeah, 339. So this is Pollen Estates, paragraph 49, and it's the second or third sentence. It's my Lord Justice Lewison. We are not parliamentary draftsmen, and it is sufficient that we can be confident of the gist or substance of the alteration rather than its precise language. The same point in INCO being picked up by my Lord in Pollen Estates. And I'll come back in due course to my learned friend's arguments about why we can't allegedly rely on Pollen Estate. Now, so what you need to do, what you, the court, needs to be confident is of the gist of what Parliament would have done. The Upper Tribunal said at paragraph 89 that it was obvious that the clear gist of subsection 5B was that if section 1259 applies, then one reads references to a company as references to a firm. Or if one goes into a little bit more detail, one can say, well, the substance of the provision is that in circumstances where you're applying section 1259, if the participation condition is met as between a partnership and a transferor, then the asset is acquired from a related party. And that one can work out by going through 5A, 5B, 5C as I did earlier. That's the clear substance of what it's getting at. So if you're applying section 1259 and the participation condition is met between the partnership and the transferor, then the related party exclusion applies and you're not in the gateway. So that's obvious. Now, although we don't need to give you a precise form of words or a suggested form of words, we did give one nonetheless to the Upper Tribunal, which it found to be helpful. And it's probably easiest to turn that up in the decision of the Upper Tribunal at paragraph 90, which is page 65 in the core bundle. It's in paragraph 19. You see underlined words have been added in. A company is taken to be carrying on the trade of a firm. Paragraph 90, my lord, of the Upper Tribunal.
Yeah.
It's page 65.
Yeah, sorry, getting out.
So the underlined words were, a company is taken to be carrying on the trade of the firm, which of course is what section 1259 postulates. And actually we say when you read this amended version of 5B, then you can see that the substance that Parliament was seeking to achieve, as I've explained a moment ago, is given effect by these words. Because what these amended words do is this. It says that so if a company is taken to be carrying on a trade of a firm, so that basically means if you're within section 1259, then references in 5A to a person include a firm, which means that if the firm or the partnership is related to a transferor, then under 5A they will be related parties. And then reading the rest of this sentence, references in this section, so if you're within those circumstances, references in this section, which includes of course the gateway in 1B, to a company are read as references to a firm. So when you're applying 1B, you read references to a company as references to the partnership. The partnership we've just worked out pursuant to 5A is treated as a related party to the transferor by virtue of the participation condition being satisfied. And the end result is that as Parliament intended, you're not within the gateway in 1B. So this is a simple form of words that's been added in. It reflects closely what section 1259 does. And when you track it through, you see that it achieves the right outcome, the outcome that Parliament intended.
I don't think anything turns on this, but there does appear to be a slight glitch in the drafting in paragraph 89 in the last line, where you need to insert something like the words to be read before as if they were references to a firm. This is recording the end of 89.
As if they were to be read. Yeah, I think one could do that, because that's the same wording in
yes.
5B.
And I think again the gist is clear, but
Yeah.
one needs to put something in as a matter of just to restore grammatical.
Grammatical. Absolutely. Thank you. So that's why we say that the three INCO provisions are met. And now I can deal with my learned friend's arguments, and that there were more of them in his skeleton argument than in oral submissions, but I'll try and take them quite quickly because they are there in writing. One submission in their skeleton is that unlike INCO, this case does not involve consequential amendments. And we say with respect, so what? There's nothing in INCO which says it's limited to applying to consequential amendments. What you have to do is take the three principles of the three criteria and just work out in any given case whether they're satisfied. In fact, Pollen Estates is a perfect example of a case which wasn't to do with a consequential amendment. Equally, a point made by my learned friend in his skeleton is he refers to a passage in INCO which says errors won't be corrected if the changes required are too extensive, too big, or too much at variance with the language used, or they won't be corrected if the subject matter calls for a strict interpretation, such as penal legislation. And that's the example given in House of Lords. It's penal legislation at page, for your note, 323 of the authorities bundle. We say none of that applies here. The extent that the changes aren't extensive or excessive, and equally this isn't penal type legislation where it might be appropriate to just let the legislation fail. The next argument my learned friend makes, and this one he did address orally, was to say, well, even if you correct the drafting error, the proposed amendments don't work. And his reasoning, at least in the skeleton, is this. In fact, I think it's the same orally. My learned friend says, well, what you're trying to do is work out the profit of a UK resident company, the notional company. And so he says it's that company, the notional company, that must be tested to work out whether you have related parties. And so he says it's not enough to just correct this drafting error. You need to go further and add something explaining what the attributes of that notional company would be. And we say, with respect, that's completely wrong. The whole point of the amendments in 5B was that related party status will be determined by reference to the partnership and not directly based on the notional company. See, the substance, and I've already said it, so I'll take this briefly, but the substance of what Parliament was seeking to achieve was that if you're considering the gateways in section 882 in the context of applying section 1259, i.e. in the context of working out the profits of a notional company, then if your partnership and transferor satisfy the participation condition, they are treated as related parties, and in consequence, the related party exclusion applies. So you don't fall within the gateway in 1B. That's the substance of what Parliament was trying to achieve with these amendments. So the whole point was you don't need to look, for these purposes, at the notional company or its ownership attributes or anything like that. You're looking at the partnership and testing the participation condition as against the partnership itself. So,
does any of this matter?
Well, it matters.
If there is a drafting mistake, and if the purpose of the amendment can be discerned, and if the drafting error can be corrected by a form of words, all of which you've submitted can be done, does it matter if the substantive changes which Parliament intended to make don't work? That's not a matter for the courts, that's a matter for Parliament. If Parliament's made a pig's ear of working out the attributes of the notional company, that's not the court's problem, that's Parliament's problem. HMRC's problem, perhaps, but that doesn't bear on the INCO principle, does it?
Well, absolutely. So I think, so I entirely agree with you, my lord. So all of this point that my learned friend has made has no bearing on the INCO principle. But I think what he says in the skeleton is, well, even if you apply the INCO principle and you correct the drafting error in the way I've said, the legislation still fails, and therefore, and the reason why that's important
may or may not do, but that's not to do with INCO.
Well, it's not to do with INCO. So in a sense, it's an additional, different argument he's raising, which is saying, well, even if you're right on INCO, I still win. Muller still wins, because these, even when you correct the drafting error in the way you say, the amendments can't apply and we're not caught. And we say,
well, except it's common ground that they are.
Well, no, it's not. So it's common ground that the corporate members and the LLP satisfy the participation condition. So that's common ground, but my learned friend doesn't accept.
Oh, I see.
He says, well, even if you correct this problem and you now read in those words into 1259, into 5B, as the Upper Tribunal did, and so you correct the drafting error, he says, well, it still doesn't matter, because when you look at the revised text, yeah, we meet the participation condition, but who cares? You meet the participation condition between the partnership and the transferor. He says 1B is looking at the notional company, and therefore you haven't proved that the notional company satisfies the participation condition. You need further changes or something enacted by Parliament to address that. And we say, well, no, that misses the point. This works perfectly once you correct the drafting error. And as you work through the steps, so what Parliament has done is it's correct that 1B, the gateway, prima facie is looking at the notional company and asking if it's a related party to the transferor. But what 5A tells you as a starting point is that the definition of related party is now expanded. So it includes circumstances where you meet the participation condition. But even more relevant is 5B, which tells us two things. In circumstances where 1259 applies, it tells us two things. Number one is that when you're looking at 5A, which tells you if you meet the participation condition, you're related, it says you can test that by reference to a partnership. So far, so good. Under 5A, the partnership and the transferor are related parties if they satisfy the participation condition. But also, 5B does another thing. When one keeps reading it, it not only tells us that in 5A, you apply it by reference to a partnership, it goes on to say that in this section, which includes 1B, read references to a company as references to a firm. So when you go back to 1B and you're applying the participation condition, when you're applying the gateway or looking at the gateway in 1B, what 5B is telling us, although 1B normally asks is the notional company related to the transferor, you have to read references to companies, references to firm or partnership. So what the gateway is now asking is, was the partnership related to the transferor? And the answer is yes, because under 5A, if the partnership meets the participation condition, it's related to the transferor. Three remaining points my learned friend made. One of them was to say, again in the skeleton, not orally, that the changes here are not rectification type amendments, but rather substantive changes that Parliament should consider. We say, well, no, that's wrong. Parliament has considered the changes. It sought to change Section 882 by Finance Act 2016. And if we're agreed, or if the court agrees with us, as did the tribunals below, that the purpose or the substance of what Parliament was trying to achieve is clear, then by correcting the drafting error, you're not bringing about some substantive change that Parliament hasn't considered. On the contrary, you're actually giving effect to a substantive change that it wanted to bring about, but by inadvertence didn't. So we say that's a bad point by my learned friend. And then the last 2 points he makes, one is to say, and I say slightly tongue-in-cheek, I'm sure he didn't say this when he appeared before you in Pollen Estates, but he says it's a highly unusual application of the INCO principle, and therefore it shouldn't be followed. And I say, well, sauce for the goose is sauce for the gander, but ultimately it boils down to this. It's saying, well, it's an unhelpful case for us, so don't rely on it. There's nothing in Pollen Estates, as my lord will know, which says it's a highly unusual application of the INCO principle. It's just an application of the INCO principle, where the court and my lordship worked through the three principles and found that they were satisfied. And for the reasons I've submitted, the same is here. So Pollen is just an illustration of how INCO works, and we say this case is another. And then the last point, which is to do with the Jones and Rotham Park Estates case. Now, it's slightly odd. This case is dealt with in my learned friend's skeleton argument, but he didn't take it to you orally, so I won't go through it in detail, but I'll very
It's
briefly...
referred to INCO.
Jones.
Yes.
Referred to an INCO.
It's referred to an INCO, but the particular passages of it, which my learned friend relies on in his skeleton, and I wanted to sort of explain why those...
Well, it was too complicated to tinker around with the Leasehold Reform Act in Jones.
Well, absolutely, my lord. So essentially what happened in Jones was this. You had an intermediate lease entered into with a freeholder. Freeholder entered into an intermediate lease, contained certain covenants. The impact of those covenants was that the price at which the tenant could exercise his statutory right to acquire the freehold went up, but the terms on which he could exercise the statutory right to extend the lease remained the same. So basically it's trying to push him in one direction rather than the other. And what Lord Diplock said was that it was unlikely that Parliament had envisaged intermediate leases would be entered into in these terms. If they'd spotted it, they would have done something about it. But the passage then which, the important passage my learned friend relies on, and I briefly showed you, is at page 308 of the bundle. Here in the bundle. So it's page 308, and do you see it's the paragraph just under A, beginning "My
Yeah.
lords" in the instant case. If I could invite you just to read that paragraph to yourselves.
It's basically, the third INCO condition was failed.
But well, what's important is why it was failed. So,
Yeah.
so what my learned friend relies on this passage for is this bit about I do not find it possible to state with certainty what words would have been inserted into the Act to fill the gap. But the important point there, when one reads the paragraph, and this is the short point, is Lord Diplock wasn't saying you need to be able to work out the precise statutory formula or the precise statutory wording. What his lordship was saying was this, and you see it in the rest of that paragraph, that this particular problem about intermediate leases substantively could have been dealt with in various different ways. And it was a matter, and you see this in the last sentence, of pure speculation as to substantively what Parliament would have done. So the issue in Jones wasn't, to the extent my learned friend, as I understood his skeleton to be making this point, well, you need to pin down a precise form of words, and the form of words you've pinned down isn't good enough. We say, well, actually, it's clear from INCO, and it's clear from my Lord's judgment in Pollen Estates, that you don't need to pin down the precise form of words. And Lord Diplock, although he starts the sentence by saying, I do not find it possible to state with any certainty what words would have been inserted in the Act, his lordship doesn't mean the precise this, that, other word. He means in terms of the substance of the words. It's not possible to know the substance of the words Parliament would have used, but of course that's, we say, is no problem in this case. It's quite clear what the substance Parliament was seeking to achieve, and in turn you can be confident of the gist of the words it would have used.
Doesn't it boil down to this? It's enough if you have conceptual certainty about what the provision should have said, even if you can't necessarily find a single form of words which is the only way of expressing that.
Absolutely, absolutely. That's right, my lord. And to the extent my learned friend was trying to suggest otherwise in the skeleton, we say that's wrong, and Lord Diplock clearly doesn't mean that. And we see that.
It's a fairly familiar context it's a fairly familiar principle in a number of contexts, including rectification cases. And you don't necessarily have to be able to show the precise words which would have been used, provided certainty about what was intended in terms of substance.
And we agree, my lord, and we say that's all we need to satisfy, and it is satisfied. As an aside, we say we can provide a precise form of words, and the ones which the Upper Tribunal...
It's always helpful just because it shows it can be done.
It shows it can be done.
It's quite a good discipline for that reason, if no other.
Precisely. So, my lord, those are my submissions, unless I can assist you further.
Thank you very much.
Thank you.
Mr. Rees, do you want to add anything? Yes, Ms. Peacock.
Let me try to reply in the order you've heard it. So my learned friend started, Mr. Tidmar started with 882. He had 5 propositions, as your lordship observed to him. We only disagree about proposition number 4. So that's the scope of the debate. He says that one has to assume that all of the real world characteristics are present in the statutorily directed world. Now, just pausing there are 2 cases that have been suggested against us. The first is that there are no characteristics in the statutorily directed world. So as my lady put it, it's a wasteland with nothing there. And if that were right, then we couldn't show that this was an acquisition from a party that was not a related party. So that's one version of the argument against us. Second version of the argument against us is that it's all characteristics you incorporate from the real world into the statutorily directed world, and in those circumstances, applying
all of the characteristics, you can see that we didn't acquire from a party that's not a related party. Now, both of those cases against us can't be right at the same time. It's either one or the other. It's either all characteristics or none of them. Our case is that it's neither of them. You're not directed to assume that there are no real world factors, so it's not a wasteland, nor are you directed to assume that it's all characteristics. Instead, properly construed, the direction in section 1259 subsection 3 is to assume that the UK resident company carries on the trade carried on by the partnership, and that directed assumption brings with it that the trade has these assets, these intangible assets that are intangible fixed assets, that it is using for the purposes of its trade, and that it did acquire at the same date as they were actually acquired by the LLP. We say that is within the footprint of the statutory direction, so we are not a case in which there are no characteristics. We're not the wasteland version. But the characteristics that relate to ownership and control of the trade are not part of that statutory direction because they are not concerned with the carrying on of the trade. Now, the carrying on of the trade is more than just selling milk or selling yogurt. You have to assume they are carrying on all of the trade in all of its aspects. And that means it has the sales that it has the expenses that it has the assets that it has. And making that assumption allows you then to apply the rest of Part 8. We didn't look at this in detail, but Part 8 gives relief for debits depending on whether you're carrying on a trade or not. So they are subdivided between trading debits or trading credits and non-trading debits and non-trading credits. So you have to assume that they are trading debits by virtue of the assumption you're directed to make that the UK resident company is carrying on the trade of this partnership. So we are not the no characteristics world, the wasteland, nor do we say that you can import the ownership and control characteristics because they are not a part of the statutory direction.
So you say everything that is included in carrying on the trade is in,
Yes,
and everything else is out.
correct.
And to use a different example, if the trade involves the use of delivery vehicles which are 10 years old, then the use of a 10-year-old vehicle is part of the carrying on of the trade, and you would know when that vehicle had been acquired.
Correct. That's part of the carrying on of the trade. But that statutory direction doesn't extend to the relationship between the party carrying on the trade and any other person.
Yeah.
Now, the consequence of that is that you can apply section 882. You can ask the 882 question and you can answer it. So you have done the computation that applies Part 8, including 882. And it's not a case, as my learned friend puts it, that the gateway is always open or the boundary is always crossed. Because if I'm right that it's an acquisition from a party that's not a related party as defined, you still have to satisfy the element of the test that requires the acquisition is after a particular date. Now, it might be said by the court out loud, well, the gateway is always open after the 1st of April, but that's what Parliament has provided. Parliament had a cut-off, 1st of April, and it asks, did you acquire after that date? from a party that's either related or not related, and you go down the route of 1B or 1C. So the idea that you can satisfy the condition by acquiring after the 1st of April is exactly what Parliament has provided for. Now, that does not envisage a world in which we are guilty of cakeism. It's very difficult to know what is the cake now and who is supposed to be eating it and having it. But we accept that the effect of our argument is that in this case we are within Part 8. But when we come to apply provisions like the tax neutral transfer provisions that rely on groups, we can't qualify. And the reason is the same in each case. We accept the import of that reason for good and for ill. But that's not a case in which we're trying to procure a convenient answer from a convenient and different answer to each of those questions. We're not. We're consistent. So in answer to the proposition that I think my Lord Justice Henderson put to my learned friend, carrying on a trade here is all of the aspects of carrying on the trade. But you don't need to go further. You're not told to go further to look at the ownership or the control attributes. They're not part of the statutory direction. And then my Lord's observation to my learned friend, I think bolstered by the reference we'd made in our footnote 3, if we test section 882 and we conclude that there's no acquisition from a related party, doesn't it also mean that you can't say there was no acquisition from an unrelated party? So my Lord put it to my learned friend, doesn't that mean that the section just doesn't work because you can't decide either question? My Lord Justice Henderson suggested that we were making a burden of proof type point in our footnote number 3. We're not making a burden of proof. It's the effect of the statutory direction, and either we're right about it or we're not. But the effect of the statutory question is you are directed by 8821B to ask if this is an acquisition from a related party. And if having asked and answered that question, the answer is no, then necessarily you have an acquisition from a party that's not a related party. And it's that fork in the road, related party or not, that pushes you down 1B or 1C. And if you answer no acquisition from a related party, then you go down 1B rather than 1C. And there's no suggestion that we're not asking and answering the question in 882 because we are. And it is significant that the relevant test is expressed in terms of have you got an acquisition from a related party? It's a related party test. It's not an unrelated party test.
Yeah.
So once one properly understands the statutory direction, we say it's not a wasteland case, it's not an all attributes case. We bring in those that are directed by the statute, no more, no less. And then there should be nothing uncomfortable in answering the 882 question in those circumstances with the conclusion that it's not an acquisition from a related party. Now, my learned friend went as far as to say, just before he finished his observations, that you can only apply section 882 if section 1259 brings in all of the characteristics. I hope I captured that verbatim, but that was as close as I managed to what he said. We say no, and perhaps that is another way of expressing the divide between us.
Yeah, no, you've dealt with that.
So for those reasons, we say there is no difficulty here in applying 882, and that our construction of the statutory direction in 1259 has the effect I identified in opening. Let me then turn to the assuming I can help you no further on that,
Thank you very much.
turn to the Finance Act 2016. Points my learned friend Mr. Afzal made, well, he reiterated reliance on the fact that corporation tax is an annual tax, and he's right. And he made the point, again, he's right, that in determining the debits after the 25th of November, you have to apply the wider notion of related party. But he cannot get away from the fact that that statutory test requires you to identify whether they were related parties at the date of acquisition. And there is nothing in the legislative code that will cure that problem. So in effect, and trying to put this as succinctly as I can, when did the related party definition change? Answer, 25th of November 2015. To what did it apply? All debits arising in accounting periods thereafter, provided that the relevant assets were acquired at a point in time where the related party wider definition applied. Our case is the exception to that we have debits after 2015, the date of acquisition of the relevant assets is 2013.
Yeah.
And there's nothing we can see in any of the points that were made and accepted below that undermines that remorseless logic. Now, it doesn't help to say you've got to construe it as a harmonious whole as amended, because you've still got to give effect to the date of acquisition. And my friend showed you paragraph 10 of the explanatory notes. I'm afraid those explanatory notes in that regard, if that's what they purport to be, are just wrong. Paragraph 10 does not accurately describe the effect of the enactment that Parliament passed. My friend pointed you to section 53, made equivalent amendments to section 845, where section 845 is concerned with transfers. He sought to pray and aid the fact that section 53 changes apply for transfers after the 25th of November date. To our eyes, that's a point against him because there is no such change made by section 52. Now, I cannot answer why Parliament adopted one drafting technique in section 53 and a different in section 52, apart from speculating that the subject matter of the provisions 845 compared to 882 are different. But it remains the case that 882 refers to the date of acquisition, and that's not altered. So for those reasons, for reasons I developed in opening, we say, with respect to my own friends, I've got no answer to the retrospective, purported retrospective application of the Finance Act 2016. On the second point, INCO, you have my submissions in opening, which I shan't repeat, that given the nature of the problem here, in a world where we are right about issue 1 and 882, an attempt to fix this amounts to legislation and not interpretation. It's just beyond the reach of a court.
Yeah.
Small point to note, but section 882.5b only amends the reference to person in 5a. So it is only extending the notion of what it means to be related in the context of the participation condition. Parliament is not expanding the notion of related party in 835. So it's telling you that when you have to apply the participation condition, and when you do, you have to apply it to firms and companies, but it's not expanding the definition of related party itself in 835. Now, that's a pointer to how difficult it would be to make the sort of change that the revenue would urge upon you, and the reason why we say that the amendment they proposed and the Upper Tribunal accepted isn't enough. Developing that latter point, our case below and here is that this is a step beyond what INCO permits. Either you accept that or you don't, but if you don't, our point is still, well, you still haven't solved the problem that 1259 directs there to be a trade carried on by a UK resident company, and expanding the notion of related party, if we're right on issue 1, is still a problem. So logically, if you're with me on the first issue, that problem is not solved by having a wider notion of related party or participation condition. So our answer on INCO is, blunter than I mean, you can't do it, but if you can, the formulation suggested isn't enough, doesn't solve the problem. And then perhaps lastly, we can debate, or perhaps Muller can debate afterwards about the where Pollen Estate sits in the INCO authorities, but for our part at least, in Pollen Estates it was with respect, relatively easy to identify the problem and relatively easy to work out a solution. We are just 1 million miles away from Pollen Estates. So those are my submissions on that second point on FA 2016 and my submissions in reply.
Thank you very much, Mr. Peacock. Right, well, it won't surprise you to learn that we will reserve our judgment. You will get a draft in the usual way, which will go to those on the distribution list only. It comes with a fierce embargo, which means what it says. It'll be your opportunity to correct our English, but not our reasoning, and not to introduce new points. We would hope that in the light of the draft judgments, you will be able to agree an order disposing of the appeal. If you can't agree a form of order, please make short written submissions, and we will make the form of order that we consider to be appropriate. The eventual hand down will itself be electronic by email to those on the distribution list and by release of the draft to the National Archives, so there will be no need for any future attendance. Thank you all very much.
Court rise in favour.